first some logistics. I won't complicate, I won't use too many big words for the beginning, because I think that we should rather start working as soon as possible. However, there are some things that are, let's say, essential for good functioning of a conference. First, the bathroom is when you it is on the left, past the metal detector behind the corner. And you do have the program. The coffee break will be organized downstairs. At the ground floor, there is a cafe where we will have coffee and something small to eat. Whoever would like to do so can accompany me down there, so that you won't get lost. The same goes for the lunch. The lunch will be organized in a nearby restaurant, which is actually quite easy to get to, but again, some 5 or 10 minutes past our last session before the lunch, I will be waiting downstairs. So whoever would like to join me is welcome to do so. One more thing. As it is already pointed out in the program, the seminar is being filmed to be podcasted later. However, I have to point out that only speakers will be filmed. So don't worry, during the debate. The debate will be recorded as well, but not the picture, just the audio, and of course the image of the speaker. So do not by any means feel inhibited by being filmed during the debate. I am available for any questions that could occur, preferably during the breaks, but if it is necessary, also in between. Now, some very short words about the seminar. The basic idea behind this seminar was that we have all got some basic information about EU law, what we should do as judges, to which extent we should use it. But these were all more or less basic information. This was basic information that did not take into account our actual day-to-day work. During this work, we all have actual situations, actual questions that are definitely not covered by the information we got on more or less academical level, when we chew and rechew the same cases all over. So what we tried to do with this seminar was address some of these actual questions. And this brings me to the first presentation, to the first speaker, who is Professor Rajko Knez of the law faculty in Maribor. And I must tell that this first topic was a year ago his original idea, what we could cover in one of the seminars of the Slovenian administrative judges. But this topic spurred so much interest between judges that we try to develop it on, to bring this idea further on with further topics that we shall discuss during these 2 days. Professor Knez has been, let's say, my co-worker in matters of judicial training for the last 10, 11 years, something like that.
Maybe.
Yeah, we came together during the initial training of Slovenian judges before the accession of the country to the European Union. Well, then that's 12 years then.
Right.
Yeah.
Right.
Okay. And I must say that during all this time, he has been one of my favorite speakers during the seminars for Slovenian judges, because he is never afraid to open a new topic, a relatively new topic, and to think openly about the possibilities that a certain legal situation opens for the judge. But I shouldn't steal his time and his topic, so Rajko, please go ahead.
Thank you for these kind words. Thank you, Andrei. Can we say that we cooperate also institutionally between courts and faculty?
Yes,
can we say
of course,
that?
yes. And if you say a few words about it, I won't mind at all.
Okay, thank you. But first, let me welcome you also in Slovenia, the court, administrative court. It is a pleasure for me to be here. Thank you for the invitation. And while my lecture is going to last for approximately 90 minutes, I hope I won't be boring, but I would like to invite you. I would be quite happy if you ask questions during my presentation. I will touch upon several issues that are really of the constitutional nature of the EU law, relationships between EU law and national law, but I would like to say in more advanced manner, because the topic of enforcement actions against member states and what happens when there is a procedure going on at the Court of Justice, what happens to national court, how the national court is affected. Well, one might say, well, okay, stop the procedure and wait what will the court say, but it's not so narrowly, that's a narrow look at the topic. I mean, the topic is quite broad. Years ago I didn't realize how broad it is, so I think I'm gonna need that time to explain you all the details. But before I start, indeed I would like to share with you one information. I could say that we are quite proud of our cooperation. Namely, as Andrei said, I'm coming from the Faculty of Law, and we started 7-8 years ago, perhaps, a project called Amicus Curiae, Friend of a Court, whereby we involve students to go to the court and to take a pending case, unresolved case. And the students are obliged to study the case and to give a preliminary info whether EU law is applicable or not, which jurisprudence is applicable. And the student has approximately 4 pages long paper to prepare, and we at the faculty, we review that papers several times. We instruct students how to do, what to ask, what not to write, what still needs to be discovered, etc. And once this information is final, once we give a green light, then that kind of information is given to the file for the satisfaction of the judge. And this is additional information, of course, for the judges about EU law. I think this is a win-win situation, win-win case. Judges got additional information. Students are actively involved, are actively engaged in adjudicating process. And we at the faculty, we are also aware of what is going on at the courts, what kind of cases are there. Last year, we spread this comparison also to the court here. Otherwise, we are working with regular court, civil court in Maribor, also with labor court, and of course with administrative court. So this is how we try to connect administrative sphere with adjudicating process. Just for your information. Okay, but okay, I'll try to. I'll try to. Right, so my topic is enforcement actions against member states and their impact on national court procedures. However, I will talk also about the impact of those proceedings to legislators, to individuals, to administrative bodies, because everything is so well connected, because if there is an influence of these enforcement actions to individuals, and these individuals are going to bring claims to the administrative court, of course we have to be aware of that also. And this is the structure of my lecture. I will use a little bit of time to make an introduction, I would say the basics of infringement actions as a public law remedy. I will use also some statistics that we can see that these actions are on one hand numerous, but on the other hand, it's not important how many actions are there at the Court of Justice, but what are these actions about? what is the issues, what is the legal course of action for these actions, and how this can influence national court procedures or national administrative procedures. One might think that there is certain action that can influence only certain member state, but there might be also actions, and this is quite often, that influence all member states. Different kind of procedures that are pending, that were also finished already, and we have to reopen it, which is especially a difficult topic, because the results of these enforcement actions can cause reopening of the already finished final judgments, finished procedures, and there is the last part of my lecture will cover also this retroactive effect that might happen with the infringement actions. And then I will go on with basics again on what are legal effects of this kind of judgment of the European Court of Justice, and how legislature is affected, how administrative authorities are affected, courts, of course. Here will be the emphasis how the courts are affected, and also how individuals are affected. I have two cases that I would like to discuss a little bit with you. I would like you, if you can be engaged as well. And then I will cover also these questions of retroactive effects, and I will try to finish with the conclusions. What are the tools of national judge being faced with enforcement actions at the court, of course, initiated by the Commission, and what we can do in different circumstances. There is no white and black rule. It's up to the circumstances. I can say that in advance. It's up to the circumstances of each case to decide what to do. There is a difference if there is a late transposition infringement case, because the member state did not transpose the directive on time, and there is a huge difference to the cases where Commission started a procedure against certain member state because of misapplication of a certain rule, because of I would say bad practice, not proper practice of administrative bodies involved, how to understand certain European Union rule, etc. It's also a difference if we are faced with the application of treaty rules on one hand, and on the other hand, directive rules from the directives. Because usually treaty rules are more abstractly written. We don't know exactly what can be comprehended with the treaty rules. Where are the borders of certain rules? And on the other side, there is a directive usually with more detailed rules, and it's easy to apply them in the practice. Right. So we know that infringement actions are direct actions at the Court of Justice, and it's one among several direct actions. And of course, it's only the Commission that can start action against certain member states. There is a possibility that member state starts action against another member state, but these are very rare situations, and usually Commission would like to stop this possibility. Member states which would like to file a claim against another member state has to give a notice to a Commission. A Commission would usually take over these procedures, because when member state is suing another member state, this also has a political implications, and this is not very good. So usually we're going to have a case, Commission versus member state, and these cases are not so rare. And once we are faced with these cases, then we have several questions. First, how certain case influence ongoing procedure at a domestic court, might be administrative court, might be any other court, might even be criminal court. So it's up to the question what kind, which legal issue is at stake in this enforcement action, and so how it influences ongoing procedures. Then another question is how influence ex post already decided procedure, and again, because since we are in the field of administrative law, the question is how these enforcement actions influences administrative procedures that are already final, so the decisions that are final, that administrative authorities already decided, on the one side. On the other hand, might be, and there are several cases, and I think in the last 10, 15 years, there were quite a lot of cases going on at national level, where administrative court finished the procedure, and there is a final judicial decision, res judicata, and then it happened a month, after a year, that European Court of Justice is issuing a decision where we can see that interpretation by the European Court of Justice is different as of national court. And is there a chance to reopen that procedure? And these 2 points, ongoing proceeding and ex post proceeding, these are raising questions, issues. Ex ante, for future proceedings, are not a big deal, because we are going to take into account what the court in Luxembourg said, and of course the case did not start it yet at home, so won't be a problem. And we all know that everything that court interprets, court in Luxembourg interprets every article in whichever legal act, treaty, or regulations on directive, right?
Yes. I have a question. When you say reopen,
right.
Do you mean as an extraordinary remedy? I mean, it's just...
Well,
in Swedish we would call it resning, and that's an extraordinary
right, approach. Right. A good question. You won't find that explanation in any court decision, because extraordinary legal remedy. We also know that in Slovenia, but in certain member states there is not such a notion. So the court will just say if it is possible to reopen, and then it's up to national legal system when it is possible, and it doesn't matter where there is a ordinary, extraordinary legal remedy. Important is that there is a chance to open it, whatever way. But that's a very important question, because here we can see at the very beginning that the solution will differ quite a lot among member states. And some member states are being called, well, put into your legislation that, for instance, time limit, but of course also the reason to reopen the case if there is a misinterpretation by national authorities or national courts of European Union law, afterwards being, of course, decided so by European Court of Justice. And this is the area that is still evolving. You're going to see in the second part of my lecture that the court put to national courts different guidelines how to react. And these guidelines differ from case to case. And I will try to summarize what is the up-to-date stand of the European Court of Justice. So somehow evolving area of law. And of course, if we are faced with infringement actions with Article 58 of the treaty, to what kind of procedures are we talking about? Of course, there are two phases in that procedure. First is an administrative procedure whereby only Commission and member states are having a conversation, so-called conversation. So they are exchanging letters, they are negotiating, I would say, and usually we don't know nothing about it. Usually there is no transparency in this administrative procedure. It's quite obvious why not. First, from the side of the member state, no government would like people to know that there is another procedure going on against member state. No government would like to give to the media information, well, we might be wrong in application of EU law. Well, yes, we are behind the deadline of certain implementation, etc. And every government is trying to get as much as possible a good result from this negotiation procedure with the Commission. On the other side, Commission also doesn't like to talk about it because might be that the case will not be brought to the European Court of Justice. Might be that they will resolve that case initially between member states and the Commission in that phase. Approximately 90% of cases are being formally settled before being formally referred to the court, as you can see. So only 10% of cases are being referred to the court. So you can imagine if there is already now, I think this is the second biggest number of claims, these infringement actions. You can imagine what is behind that, how many procedures are going on between member states and the Commission. And usually Commission reacts on the information given by citizens. And this reaction from the Commission that start the case, at least on this administrative phase, as a infringement case, well, I would say that Commission really like that kind of information. For instance, just my experience a month ago, I was just asking the Commission whether it is okay if member states, in that particular case Slovenia, demands payment of taxes and duties from EU grants. As you might be aware, every member state conclude an agreement between member states and the Commission when there is an article, a short sentence, taxes and duties from EU grants are not to be paid. Basically, I think that every member state has this treaty. I have several projects from EU Commission, Tempus project, Jean Monnet project, etc. And if I pay taxes, that means that I have to pay to the state approximately 63% of that money. So 63% of EU money is going to the state budget. There are states, for instance Croatia, where this percentage is 73. So on one side, one can say, well, let's put that taxes to EU grants and we will get money from EU to national budget. So I was just asking with an email to the Commission, and I got a notice, a feedback from the Commission in several days, saying that I started infringement action. So that I give information for the Commission to start the infringement action. And I had to give them, they were asking me to give them additional information, which kind of taxes, what kind of contracts, etc. And now I've got a number after a month that there is an infringement action against Slovenia. I never meant to start the infringement action, but I would just like to give you that information that the European Commission is really keen to get this kind of information. Approximately 70 to 75% of infringement actions are started against member states due to the different kind of information given by citizens, by us non-citizens, companies, etc., to European Commission, asking them something, whether it is okay in the member state or it's not okay domestic member states, foreign member states, etc. Right. Infringement action is an action which is in the sphere of public law remedy. It's not a private law remedy. What I'm saying is that Commission is going to start an action if there is a public interest behind that. So Commission will not start an action because of me, because of you, right? And the Commissioner will give you feedback information in the notice saying, don't count on us. Start your own procedure at the domestic available remedies. We might or we will not start the procedure. And even when the Commission starts the procedure, there is no guarantee that you will gain, that the individual will gain anything from this procedure. The individual is not party to that procedure. The individual is asked to give evidence, but it's not party to that procedure. But yes, at the end of the day, if there is a decision by the European Court of Justice saying, well, member states, you did breach the law, then individual, of course, can use that judgment in another private law remedy procedure in that member state. So usually what is going to happen is that individual which would like to invoke in private law remedies, saying like individual against member state, individual against another individual, individual against the company, etc. And there is a question of the proper interpretation, proper use, proper implementation, etc. of EU law. The individual can start that private law action, but at the same time, he will use a form which you can find on the internet, a complaint form, sending to the Commission while certain member state is not in line with EU law because of that and that and that. And even more, the individual can file that complaint saying another company is not in line with the EU law, which is of course a horizontal relationship, and sometimes the EU law is not applicable in horizontal relationships. However, that individual will say, and the member states is not doing anything against it. So member states should be active and forbid that company to violate EU law, not to respect it. And again, there might be a infringement action started against member states. What I would like to say is that individuals are using that public remedy, information to that public remedy, to information action, as an additional pressure to the member states to do something. You know, and it's very good if that infringement is taken seriously, and usually it is by the Commission, and you, individual, is engaged in that process, being aware what is going on, and at the end of the day, indeed, the Commission wins the case at the court. Of course, in that case, from the individual point of view, somebody else did something what individual should have done, but of course that would demand from him time, nerves, money, etc. So, infringement action as a legal remedy in public interest on one side, and or other private law remedies can go hand by hand. They are not exclusive. One is not excluding the other one. So might be both actions started at the same time or with different in different time frames. Doesn't matter. The supervisory role of the EU Commission is not the same in all areas of law and EU politics. As I said before, there are areas of law where information from individuals will be very useful. But there are certain areas of law where there will be no information from individuals. For instance, environment. Usually, there is no information about that member states are not in line with the EU directives in the field of the environment. Because with the environment. Because environment cannot file a complaint. right? The nature cannot file a complaint. There should be an individual filing the complaint. And usually, in all member states, states are the one who are taking care of the environment. They have a competence to taking care of the environment. And of course, the state will not start the action or give information for starting the action against member state. So there are NGOs perhaps that will give information, but usually there will be nobody. Therefore, the Commission has to be active. And there are tenders searching for researcher performers that would give the Commission an overview and a review whether directives are correctly transposed to members to national legal system or not. EU Commission needs a voting in favor of starting the infringement action by the commissioners. So this is not the wish and the idea, and at the end of the day, the decision of each individual commissioner. They're discussing things, and if they agree, then they will start the procedure. So usually, if they will not agree, if there will be an opposition, they won't start the procedure against member state, and everything will finish in administrative phase. And you, as a judges, you will have no clue about it. You will not know anything about it. As I said, there is no transparency. Only once they start at next phase of the procedure, when they file a claim against the member state at the European Court, you will be notified, but not personally, but with the EU announces, official journal announcement. Official journal of the European Union announce every single case, so you might find out. But, well, I don't know how much you read Journal of the European Union. Do you? No. You know that Journal of the European Union, official journal, is issued every day, and not one. There might be some days that they are not issued per year, some days. But usually, you know, Syria C, Syria A, Syria B, they're issued every day. I used to have that electronic announcement. I don't read anymore because it's just too much to read. So might be that this is not really effective. Right. A little bit of statistics. I'm not showing here these tables how many infringement actions is initiated against certain member states. Not at all, because this is not what we are looking for. It's not important how many actions are there, and it's not important against whom certain this is the same table, just a few notices. It's not also important against which member state. What is important is why. If there is a late transposition infringement case, this will not be of huge interest for the judges in another member state. So if there is a case, I don't know, against certain member state because of the late transposition infringement, because of the late transposition, judge in Slovenia, well, totally irrelevant. But if there is an infringement case whereby Commission is saying whether you don't apply certain directive correctly, you don't apply certain article from treaty correctly, and there is in one member state, but in another member state the judge is saying, well, but we do the same thing as in that member state, so this decision will definitely influence our procedures, maybe by way of the confirmative decision at the end of the day. Maybe we're going to find that we also misinterpreted provisions so far. Well, in that case, that judge in another member state has to be aware what is going on with that procedure. So the legal consequences of each cases are that are relevant, and not how many cases are initiated against a certain member state. We also have to be aware, there is an unwritten rule, that the Commission usually does not start procedures, infringement procedures, against new member states immediately. I think in case in Slovenia, we waited for the first infringement case several years. Even in case of state aids, where the Commission is very sensitive because there is a Commission has a exclusive competence in that field. Even in that cases, we were quite left alone. But once they started several years ago, then we were faced basically with 5-6 infringement actions per year, even more cases in administrative phase because of the state aid. And now we are faced with the consequences. Right, in this couple of years, for instance, we have a huge state aid cases where Commission said, well, that company should return money together with the interests to the state budget. The most infringed areas of rules, as you can see, 20% environment. So even though there is no information about infringement, or very, very little, there are 20% of cases only in that field. Here, the Commission is very active, trying to find possible infringements in national legislation. Well, if I may make a footnote about the environment, I think even though on the first impression we did destroy the environment quite a lot in the last 50 years, from 1980s on, European Union is doing, my impression, a good job in the field of the environment, in the sense of the legal rules, in a sense of the supervision, in a sense of future plans. And I don't think there is a continent on the world that is paying so much attention to the field of the environment as European Union. And this 20% is not surprising me. Then we have 15% of the transport, taxation 14%, and 30% of the internal market. These three areas, usually, information are received by citizens, by companies. And you can see 38 rest of policies, which of course are less than altogether in these four areas. Numbers of infringements in relation to late transposition infringements. Here you can see that late transposition infringements are, these are blue are late transposition infringements. These are not so numerous as other infringements, meaning that legal issues are at stake, not the time, not the transposition, not the time limits, not being inactive, state being inactive, state legislator, but misapplication, misinterpretation, etc. of rules. And this is another criteria whereby we can find that these kind of actions are not to be ignored, and it's good if we know that certain actions are going on or being decided. Especially, I think it's important that we are aware of infringement actions which relates to Treaty of Functioning European Union. There are several reasons. Firstly, treaty is unification. It's not a harmonization. In every member state is the same. From the first word to the last word, it's just the same. So we are all in the same position. Secondly, treaty includes rules that are written in abstract manner. We have principles. We have basic rules on internal market freedoms. and we don't know exactly what is the frame of that of certain rule. We don't know how to interpret exactly certain rules, certain words. So there is a place for the interpretation. And where there is a place for the interpretation, one may interpret that way, another can interpret another way, and of course we cannot be certain. And we know how difficult it is being a lawyer if you are not certain. And at the end of the day, you have to make a signature under certain decision, and you're not totally aware of, you're not totally confident if the interpretation was okay or not as a judges. But you do have a possibility of preliminary ruling. Imagine the administrative authorities which have the same situation. They also have to put a signature below certain decision, but they don't have that possibility that somebody else instead of them would say what is the proper interpretation. But of course there is a legal remedy if the individual would like to use against a certain decision made by public authorities, but nevertheless. How do we know that there is a procedure? I touched a little bit that question before, and I said that there is no transparency in the administrative phase, and there is a publication in the official journal, which I don't think it's effective. Media will try to publish that news quite often, but not in any case, especially when actions concern something that is interesting for the public, that will be published by the media. But I don't think that it's good for judges, putting another word, media should not be the one who will give information to judges, not at all. Sometimes there will be a pressure. There will be a pressure in that media news. So this is not a good solution. What I propose is to search in the e-databases where the main point is what and how to search. Meaning, if you have today a case on your table and you have to know, okay, you are competent, you have a jurisdiction. And the next thing you have to know is which law is to be applicable. And of course, we start with the viewpoint of national law, but I always teach my students also in the first year, don't start that way. That comes as a number 3. Start with international law and start with European law. You might say to yourself, well, no, and then you apply to national law quite often, but there might be cases where nobody will be aware, well, wrongly said, well, you won't be aware that there is an EU law. I will tell you one case, it's our case, Slovenian case, but I think it's very illustrative. In Slovenia, I will shorten it a little bit. In Slovenia, we officially erased companies that are being inactive for several years. Okay? So there was a law saying to the courts, to the registered court, you have to erase them. And claims that are open and cause for that procedure should be borne by the owners, shareholders, right? Do you think this is a case of the EU law? Is it the case of international law? Or is this purely national solution? And it is a purely national solution, but the problem is whether this is a purely national law. I think it's a EU law. I think it is an EU law. You know why? Who will go to such a member state, establish a company, and then, because there is a project, because there is a chance to earn something, but then, after that project ends, there still might be projects. So I'm not closing that company. I'm leaving the company alive, but nothing is going on with that company. There is no business. And after 2 or 3 years, somebody will erase me because I was being inactive. And another thing, I as a shareholder, I as the one who owned that company, this is not a legal term, but I established that company, I will have a burden to compensate all possible claims that are still open. And that might push me into my own bankruptcy. And there are thousands of cases of personal bankruptcy because of that solution in Slovenia. Why I think it is an EU law? Is anybody from Greece here? There was a there was a case, a Greece case at the EU court, whereby your media law has that kind of the provision. If managers do something wrong, and there is an administrative penalty, right? The owners are responsible. And the court said, this is almost the same thing, you know, because we are lifting the corporate veil, and something that is going on in day-by-day management basis, it's now shifting to the behind the curtains to the shareholders, and they have to pay the penalties. But they don't know anything what is going on. If I have a share, I don't know what is going on in that company. I will be informed on the assembly once per year, but on day basis, I don't know anything about it. And there was a case at the Court of Justice. The court said, well, this is the infringement of the free movement of capital. This is a burden because there will be no investment, foreign investment in the media's company. But the court decided so, right? So if we take this decision to Slovenian case, then there is an EU law that we have to take into account. And of course, you will find nothing, if you see the provision of the free movement of capital, you won't find anything like that. There is no terms of shareholders, of management, etc. So we have to know what is the borderline of that provisions, what everything we can put into that provision. Going back, yes.
Sorry to come in on this specialized point, but I can't see that your example of the Greek case is really relevant to the case of the automatic erasing of a company from the register after a number of years of inactivity. This is a case which must be very common in most EU countries, and it's usually because of the failure to comply with the procedural requirements of the country in which the company is registered. It's a procedural failing. It's usually a failure to enter annual accounts, for example, would be a reason to strike the company out. Now, if you are right, this would mean that member states would have a judge of member state, a registrar, would have the right to send such a matter to the Court of Justice in due course for a preliminary ruling on such a basic principle. I personally am not convinced that there's
Thank
a
you.
real connection
Thank you.
to the EU.
Very good. I'll try to answer you. But first, you're from different member states. Can you say that this automatic possibility for automatic erasement of the company from the register is legal in your member states?
Well, I'm from the United Kingdom. It must be very common in common law countries.
It is. It is. Okay. What about the costs?
It doesn't cost anything to just.
What about the claims that are existing, right?
I'm from Croatia, and we have the same problem about raising companies from register. And the problem is with pending cases especially, for example, if you're selling somebody's property in land register, then you have to write the enforcement case,
Mhm.
and if you erase him, the case spent, and you have real estate that is actually owned by a company that doesn't exist anymore, and my case is in that lane. You know, we can't move forward, backward, so we have a big problem
Mhm.
with the raising.
We have a system in the United Kingdom. In such a case, the claimant has a civil claim against the company, can apply to have the company restored to the register for the purpose of the litigation. So there's protection.
Okay, the protection. But do you think, two questions emerge on my opinion. This is proportionate, secondly, this arrangement. Secondly, is it okay that the shareholders are liable for all costs and claims that are outstanding?
There are no costs in the erasure, and as to the civil claim, it's an ordinary action, like any other action. Of course they are liable.
They are liable. So lifting the corporate well would be okay.
Well, they're not personally liable. The value of their shares could be affected by the litigation.
No, in Slovenia they are personally liable.
No.
Yeah. So, in my opinion, this personal liability is a huge problem,
Sure.
right? And
That's the Greek case.
that's the Greek, and that's the same in
I
Slovenia.
don't think it's the same with the erasure case. That was my only point.
But we are also personally liable as the shareholders of that company that is erased,
Right.
right? It's a case going on also in the European Court of Justice in Strasbourg. It's a pending case.
You mean that the shareholders will have to be bankrupt?
Yes. We have approximately several thousand, we don't know exactly how many shareholders are in bankruptcy because of that personal bankruptcy.
They don't just lose their shares value.
No.
They lose their everything.
They are personally liable with all their assets, with my house, with my, right?
That's a big difference.
That's a big difference,
That's the big difference.
right?
I
Right.
agree with
For
that.
Yeah.
instance, in Italy, the company there are shareholders. They're only responsible for the value of the shares.
No.
So the problem wouldn't exist.
Right, but we did go a step further because usually that value is very little of shares.
So you made a big leap.
Yeah. But I just wanted to illustrate that's national, totally national case, total national idea how to regulate something might influence by EU law, right.
I also understand.
Right. What I'm saying is, when you have a case in front of you, think about European Union law, and I think that's first step is really very important. Sometimes you might find something in the database.
Just
Right.
Another precision. I mean, if that means that if a United Kingdom company establishes itself in Slovenia, the United Kingdom shareholders would be subject to the Slovenian law about their personal liability.
Right, there is no discrimination, which in that case is vice versa, right? But yes, not only Slovenian citizens, but it doesn't matter where the shareholder is from.
Wow.
And you see the point now.
I doubt if they all know about it.
You see the point now. Who will go to the country to invest? For instance, in that case, you are searching for that case about the personal liability, and there is a capital at stake. You search for the free movement of capital, and you're going to find cases. And judgments of the European Court of Justice are very well written, because I'm not saying from the substantive point of view, but how it is structured, because there is a summary at the beginning, and you can find quite quickly whether the case concerns your case or not. So if you ask me, I usually start reading summary. And then if I see, oh yes, this is the case. Wait a minute, I have to go deeper in that case. Then I will go to read the case. Then I will go to read opinion of Advocate General, etc. And the defendant, as I wrote here, it's not important at all. Exemptions are, of course, late transposition infringement cases. Right, now these are real questions. What shall do the courts, legislator, administrative authorities, individuals, when there is a case of the ECJ and they are faced with the same alike issues or questions? To answer this, we have to know what are the effects of the judgment of the court in the infringement cases. First of all, the judgment given by the court has most of the time declaratory effects, saying only, yes, member state, you did breach the law. And that's it. And you have to bear the cost, which is only of interest of us because we are a taxpayer. But that's it. But the message is still very strong. The message to everybody else, message to the legislator, oh, I have to do something else. If there is a wrong implementation, message to the government, because the government did not propose the correct text of the national legislation. Message to the individual, and this we come to the courts. Individual is now aware that there was infringement by member state, and that individual was perhaps part of that infringement because he did not get a right that otherwise would be given to him. So that individual will most likely start an action against the member state. And here we are with a retroactive effect that I will take care a little bit further on. Of course, if there will be another, we have a decision by the European Court saying, member state, you are in breach, you have certain time to cure that breach, and that breach is not cured, of course the Commission can start another procedure. At that time the Commission will also demand the money penalty. I'm not talking about that tomorrow. It's outside the scope of our lecture. I just want to point out that after the Nice Treaty, this is possible in the first action in case of late infringement, in case there is an obvious that member state did not implement the directive correctly, or it's a late interpretation. But otherwise it would be a declaratory effect. Another effect of that judgment is the question whether it's an erga omnes effect or it is an inter partes effect. Usually all commentators would agree that there is no erga omnes effect, that it's only between the Commission and member states. However, as I said, the message is very strong. But then I found, surprisingly, that I found in the literature that this is an objective kind of claim and not a subjective dispute, which I cannot really agree to that, at least from my point of view. The objective dispute is, for instance, preliminary ruling dispute, whereby the European Court of Justice doesn't care where the parties are from, doesn't care who is going to win at the end of the day the case. It's just giving the interpretation. So for the Court of Justice, within the preliminary ruling procedure, what the Court of Justice really cares is how to interpret a certain provision. But in that case, in infringement actions, the court is not taking care only about the interpretation, but at the end of the day there will be a judgment, well, member state, you did something wrong, or you did not do something wrong. So I would say it's a questionable. This is really objective. I would say it's a subjective dispute, but it doesn't matter really very much for our purposes. What really matters for our purposes is that this is the judgment with inter partes effect, not erga omnes effect, meaning that individual can now go and try to start a private law legal remedy and invoking that judgment, infringement from the infringement procedure as a proof, as an evidence that there was something wrong in the member state. But still, an individual will have to start alone that new procedure from the private law remedies. Whether it is ex ante or ex post, well, certainly it is ex ante, but might be also ex post, and I will explain a couple of issues, cases also, where decisions of court in infringement cases did have a retroactive effect. In this slide, I'm dealing with different effects of the infringement actions to the court, but if there are late transposition infringement cases, there are different effects as from other cases. If there is a late transposition infringement, there might be that, okay, we have a national law which should be changed or newly adopted by certain directive because of the implementation. And there is no implementation, and you are faced with a case. So certain individual is asking certain right, for instance, against member state, against foreign member state, and you do not have that directive that individual is invoked in your legal system. Might be that there is no legal ground. Sorry, can you help me? What would be the exact saying for legal ground in English legal system? Legal basis. Because I've heard that legal ground is not. It's quite good. It's quite good. So that you might have no legal basis to adopt the decision because it's missing, because the legislator was not active. What to do in that case? Well, direct effect, it's possible. If it is possible. If you have a vertical relationship, if you have a horizontal relationship, but still there is a directive, but there behind the directive there is a general rule, there is a general principle from the treaty, Mangold, etc., cases where you can also invoke them. But you will be left with no consistent interpretation. Why not? Why there is no consistent interpretation? Because you can only apply consistent interpretation in cases where you do have domestic legal basis. If there is no, inconsistent interpretation, the legal basis is in the domestic law, just interpretation is taken out from the European Union law. But if you don't have that, of course, there is no legal consistent interpretation. It's only direct effect. However, you might have an applicable domestic rule, international law, because that directive, for instance, the issue covered by that directive was already part of the national law. Of course, implementation is still missing, but nevertheless, there are some rules in national law. And in that case, of course, might be both direct effect and consistent interpretation. Well, if this is not possible, what then? Then individual, not you as the judges, but individual is left with the liability for damages, for compensation by member state. If we have other types of infringement, as yes.
They can bring action against
state, yeah?
Right.
If they don't rule as judgment, as previous judgment, yeah? You think that? If they rule, and I don't understand in what he will say in that action against state.
If I'm that individual, and there is a certain right for me waiting in that directive, which was not transposed correctly.
Okay, I was thinking only the national court, they are not obligated with the judgments before. Now you was talking about the legal effects of the judgments in enforcement procedures. So as a judge, am I or not obligated with some other judgment? No. Yeah.
No, you're not.
It is not erga omnes, it is inter partes.
Right, you're not. You're not.
So what are effects of different judgments?
But trying to explain a case. You have a case where interpretation, if there would be no judgment by the ECJ, would go in that side, in that direction, right? But since there is a judgment given in the infringement case, you know that the interpretation should be different. So even though there is an...
It's again a question on interpretation.
Yes, but...
It is not the exact rule. Yeah?
No, but if you can solve your case with the interpretation, then...
But that means that the judgment again obligate.
I'm just saying that the message is strong. That the message is strong, because otherwise what can happen if you don't respect the judgment at all and you go that way, that direction, that individual will seek another legal remedy.
That's my interpretation. I'm not guilty.
Okay. Well, just let me finish. No, you're not guilty.
You say that it's not. You say that it's not obligated. If I judge interpreted different judgment before, why is that? Why is that the state liability? I don't understand.
Yeah, I'll try to explain. You follow your interpretation, right? And that individual is not satisfied with it. He's saying, well, there is a different member state, it's different by the European Court of Justice. And he will go on. He will go to the court of the last resort, okay? The court of the last resort will also follow your way of the interpretation. So that individual, at the end of the day, will be faced with a solution that is not good for him, knowing that there is another solution somewhere else.
Yeah.
And what will he do? He will file again a claim in a new procedure. This time, that claim will have a different legal basis. That individual will claim the government, saying the judges were misinterpreting the EU law, not taking into account something that European Court of Justice already interpreted.
So for the Supreme...
Just a moment. And in that phase, that first court, the first instance court, will be faced with the question whether that interpretation was correct or the other one was correct. So the court, the judge, the best way that he can do is to start a preliminary ruling procedure. Because he will be faced also with the question that there was a Supreme Court saying that this is A, and I, which was on the first level in a new procedure, saying this is B. So I'm saying differently as a Supreme Court. Okay.
I just are you not supposed to, if you are in doubt about interpretation of a USC directive or whatever, the way it is transposed in your national law, aren't you supposed to go to the court, European court, ask for the correct interpretation?
Preliminary.
There is doubt, we
Not
are
in the
supposed
first
to go.
instance, but Supreme Court is obligated the first instance. It's not. On the last instance, yeah.
All judges.
But that is, if I can just notice, that is in Croatian legal systems, there are big changes now when we are entering
European Union, because in our constitution the judge rules on the law and international treaties. So this is now new. Especially you have cases with consumer law. There is now collective judgments.
Collective redress.
And now court, municipal court, must follow one judgment of commercial court that he rule in collective, he bring collective judgment. And that collective judgment obligates me on municipal court when I decided in tort law one person against that commercial law. Yeah, and that is now a problem because Constitution says we rule on the basis of the law and not the other judgment.
No. Can I answer before I give you a word? Croatia. But you know. But let me tell you this example from. Is anybody here from Bulgaria? Yes. Right. Apparently, according to the opinion of the judges at the European Court of Justice, your court in Sofia, administrative court, are you part of that court?
Yes.
Yeah. Great. Is very good, and that you invented a system which is not a new invention, which is exactly that problem here, right? So you're not listening the higher court, but you're asking immediately preliminary ruling to the, you know, that's the solution. That's very good. That's very nice solution. So instead being burdened with the higher court or the Supreme Court, go even higher, go directly to the European Court of Luxembourg. And I have to say that judges at the Court of Justice are saying this is a very good, a very productive court, and we like them very much. So congratulations. But you know that's the attitude. You don't have to listen to the higher court, the Supreme Court. If you think that they misinterpret it, you just go to the Luxembourg. But in the case that I started to explain is, if in a situation, if the Supreme Court would still following your way of the decision, not taking into account something that is already ruled, because you know the court has to do everything to be in line, everything possible to be in line with the EU law.
Doesn't Croatia constitution suppose you to rule according to the treaties also?
Yes, there is now
because that was the way we used to introduce the in Italy the obligation to rule according to the European laws, and and also to the judgments in so far that the judgment gives us the interpretation of the law. So we are supposed to rule according to the legal to a way that the law is respects to the way to have the law respecting the treaty.
Yeah.
So if there is a judgment that tells us that the only way that the law respects the treaty is to interpret it this way, then we are supposed to follow that interpretation.
May I offer an easy way out? We are all judges. We all know no two cases are the same. So whatever my highest court says, whatever European Union court says, if my case doesn't fit, it just doesn't fit.
All right, please. Yes.
I think it's the point is the court is not obliged to follow the opinion of the Supreme Court of the European Court, in the sense keeping in mind that also these courts may change their opinion due to the better arguments in this case. So maybe it's in theory, but in this sense you are not obliged to follow them, because you can, in the same question, you can decide against the opinion of the Supreme Court or of the European Court in the hope that now he understands you better argumentation. Sometimes the Supreme Court. Yes.
Right. Just a moment. Let's go.
Yeah, no, I think I'm
You're done. Okay. In that respect, I think the case Kubler, you know the case Kubler? It's a very nice example. They have, yeah. This is it's a very nice example. I mean, the pure professor did not get anything at the end of the day, and no compensation, but I mean, the legal rule was fantastic, right? You know, just in a few words, the Kubler case, there was a professor from Austria that claimed that certain benefit, financial benefit, he's entitled to, and that certain benefit was available only for workers that was employed by certain employer for several years. But he left in the meantime. He left to another member state, being employed there, and he came back. And because he interrupted that labor relationship, he was not entitled to that fidelity. And he was saying, well, this is not correct, because I was just enforcing the movement, the free movement that treaty is offering me, so I should not be discriminated. If I would stay at home, in that case I would get it, but I was good, I was working hard, so I also left out and come back, etc. Nevertheless, he lost cases at the national level. And then when he came to the Supreme Court, he started a new action on the first level against the member state, against the government, because the courts in Austria did not follow the EU law. Well, the case ended in a way that it was not a mistake by the court so severe. So there was a mistake, but not so severe by the court, but then Austrian courts, and thereby he was not entitled to the compensation. But from the procedural point of view, we can see what can happen. Even though, if you come to the end, to the Supreme Court, and there was no account given to the EU law, then you go from the beginning with a new claim, a new legal basis, asking for the compensation. But on my opinion, compensation is very hard to achieve, and especially because there is a notion of sufficiently serious breach, and that sufficiently serious breach is hard to achieve. And again, Kubler showed us that's so hard to achieve, this sufficiently serious breach. Right. Can we go back? Right. When we are faced with other types of infringement, like wrong implementation or wrong application in practice, then we also have direct effect and consistent interpretation. So even though there will be a case going on, infringement case, and there is another case at home, individual versus member states, for instance, you can still judge with direct effect and consistent interpretation. But you might say, and this is up to the rules of national rules, procedural rules, well, I will wait. Or you even might say preliminary ruling. And the same question will go to the court. The court will be faced with the question from the infringement case whether member states was in breach in the EU law, and here you have the same question: how to interpret something that you think it is in breach in the EU law. And both questions, here will be a preliminary ruling question coming to Luxembourg, and here will be an infringement case. Now, these cases will not be brought together, will not be joined. Article 54 of the procedural rules of the European Court of Justice is saying that cases of the same type may be joined. Same type. So the court will be dealt differently in different procedures with these questions. Slovenian Constitutional Court did not refer so far, have not referred so far any question to the European Court of Justice, but they were faced with the question of data retention directive, and we all know several weeks ago the court judged that data retention directive is annulled, and Slovenian Constitutional Court asked himself whether to ask a preliminary ruling, although I think Austria and Ireland already asked that. Well, it would be proper to do so. However, the procedure were going on for more than 1 year, and the procedure was in the final stage. And by asking a question from the Slovenian Constitutional Court, we will stop that procedure. Well, stop, at least for a little while. So the Slovenian Constitutional Court says, well, we should not make troubles. Let's just wait until the courts decide. But anyway, we have the same questions as Austria and Ireland have. So they did not refer. I don't think that's a bad practice. This was quite criticized in Slovenia among the scholars that courts should ask questions, should have asked questions, but I don't think, because there will be a little mess. There will be a stay in the proceeding of the court, and we were awaiting that decision by the Court of Justice, what is going on with the data retention directive for a long time. Right.
Just short question. How long is approximately the time to wait or
Preliminary ruling?
yeah, for the
It used to be 24 months. Now it's approximately 18 months. It's 18 months. It was the lowest was 18 months 2 years ago, and now perhaps it's now 19 to 20 months.
How does it affect on the responsibility of the state to ensure quick judgment and the length of the
You mean judgment at the European Court of Justice?
Court of Justice, the national courts, because we have judges in Croatia have personal responsibility if they don't liability if they don't make a rule judgment in that certain time.
That's not in line with the EU law.
Problem with the length of cases.
That's not in line with the EU. At the outset.
I think not, because it's a break of procedure, and when it's a break of procedure, then don't count in the judge and the
Right. Should be like that. Otherwise.
I think when it's a break, then it is not time that.
Yeah, we made it.
Otherwise, this would discourage the national judges to ask preliminary ruling.
Similar rule, it's a relatively new rule, but we have applied the same rule since we have acceded to adhered to the European Convention of Human Rights.
Mm-hmm.
But now this rule is a constitutional rule. And the judges also are responsible if they don't respect the reasonable time of the procedures. But it is not a question of European law. It is a question of so-called human rights. But in that period, which we analyze as reasonable for the proceeding, we take into consideration the period if the judge considered necessary to refer to the European Court of Justice. We take that period into consideration, and we don't not consider the judge responsible for the length of the procedure. So it's we take into consideration the criteria that European Court of Human Rights gave already in its case law to appreciate the time and its reasonable nature, its reasonable
But can I ask something? I know why I asked, but it's too detailed, so I will not explain it, but just generally. What about international law, European law, and national court? So I have one international rule, and European law, it's making something different. Me as a judge, what I will follow?
It's a huge topic and tough topic, but try to answer. Tell me just, is EU part of that international treaty?
No, but the all member states
Are.
I think Paris Convention. I think that the EU. It's from
Well,
1019.
from the case Cadi on, you know the case Cadi? Cadi, yeah. From the Cadi case on, that was case about this person that was, his financial assets were frozen because he was on the blacklist on cooperation with Al-Qaeda. And there was a question whether to respect EU law or resolution of the Security Council. And in that case, the European law decided, well, it's up to EU law to say what is going to penetrate, to enter into the EU legal system. We have to follow the EU legal system. There was a huge, I would say, a Copernicus intervention, I would say, because before Cadi, the court were saying, like in your relation with EU law and national constitutions, as long as, this is a Lange case, as long as you will not interfere, we will take into account that, etc. But in case Cadi, there was a huge shift, and it's EU law. It's differently if EU law as an institution, European Union as such, is part of that convention. In that case, you can refer to the convention also. Generally speaking, it's EU law, it's international law, it's EU primary law, it's international law, and on the third place is a secondary law of the EU, generally speaking. But this is real generally, you know. Okay. Any other question? Right. Well, we are left with 18 minutes and several slides still. I have two cases which I will explain. And of course, I'll be happy if you discuss, but not so in detail as I wanted to. Imagine that the EU Commission starts action against certain member state, maintaining the directive on services from 2006 on the internal market is not properly implemented. That member state's demands for foreign companies which perform services on a continuous basis for indefinite period to be deemed as established and that is obligatory in that case it is obligatory to register a branch office. So if somebody is performing services in a continuous basis, then okay, then you are involved in our market. You are integrated in our market, so at least you have to have a branch here. That is the national legislation of that member state. In your member state, different member state, the same provision applies. And that's one thing. Another thing, and you are faced with an action for annulment of a decision issued by the competent inspector, demanding from the foreign company to pay penalties for performing activities, services, without any legal form, also without the branch. How to proceed? So you know, there is a case going on, not against your member states, against another member state. The issue is the same. What is it going to do? Any ideas?
We've already answered that. Wait.
Right.
What about the terms for decision?
Well, no. Well, of course, you ask the parties. You tell them about the other case going on at the European Court,
Yeah.
and you say, well, it would be wise to wait, or then maybe you refer your own case as would be the alternative.
Alternative or
well, cumulative alternative, whatever you wish.
Okay, great, right.
Wait and see what the European Court does. Send your own case there and wait for what the court does, or then you decide on your own law and face the threat of your own decision being
Right.
Not in line with European law, and your own decision being annulled maybe at the higher instance or whatever, or not worth the paper it's written on.
Right.
A few days later.
Right. Right.
Yeah, but I would suggest, I mean, I agree in principle, but if you're not the last instance, and we all face we call it balances in Sweden, you know, the cases coming in, the cases coming out. So the important is balances. I think the European Court of Human Rights in Strasbourg, they have a balance of 89,000 cases at the moment, and they have 47 judges. And I would say that if you're not the last instance, your legislator has a responsibility for implementing EU law, and I would say that it would still be possible for you to rule according to your national law. That depends on how clear you find the situation of EU law, because perhaps it's better just to resolve that case, because I mean then of course, but if you're the last instance, I mean then you can't. At that moment, if you know that the Commission has started an infringement proceedings, then you're aware that the legal situation is not clear. And then it's obvious that you either ask yourself in some preliminary ruling, or you wait.
Yeah, also possible. But why I took this case? I took this case because in that directive on the internal services and the internal market, it is written in the preamble that no branch office is necessary. In the sorry, I was too loud. In that directive, 2006/123, yeah, in the preamble, it is written that freedom of establishment in the case of services is regulated differently as in all other cases, and saying in the preamble, no branch office is necessary. In the preamble, you will not find that under articles. So can you use also direct effect, which you are referring to basically, saying, well, I do believe the Commission is right. That's why the Commission started the procedure. You do have in your mind, well, there was an administrative phase. The Commission is knowing why it started the procedure. So to decide, as you said, and you also direct effect. Not
direct effect of preamble is.
No. It's a direct effect of article. I think it's 14 article, but in the line interpreting in the with the preamble, right? Well, surprisingly, there is a lot of member states. There's a lot of member states saying that at least branch is necessary, right? Can you just raise hand in which country there is a regulation that at least branch is necessary?
You know,
Slovenia.
we had a similar case in Italy. We had not exactly similar, but almost. We had all the Italian law doesn't allow bet taking. No, bets are not allowed. We can have unless it's state directed.
Right.
And to do it, they have to get a special permission from the local police department, which are not given, simply not given, because there is this legal prohibition of establishing betting institutions at every level. So we had all the United Kingdom great betting companies, which were trying, and they did enter now, the Italian market. And so they all started legal procedures at the administrative level because they weren't given the right to establish an office
So it's up to the it's not a concession. It's not a concession.
It's not a concession, but they have to have the legal permission of the police department, and they weren't given it.
Yeah, it's almost the same. Yeah,
so they started the procedure, the legal judicial administrative procedure against these refusals, claiming the right, the EU law right of establishment.
Well, my opinion, they should not be discriminated.
They won.
They won. Okay. Right.
But we didn't rule at the court level.
If I could say something on
Sure.
this topic, this is a particular situation in this case because in this case, when it's about game of finance, the freedom, this freedom,
Establishment services.
Establishment, this freedom, in these cases, the European Court of Justice admits that the national law can impose many limitations because this field it's a very sensible field, and the limitations, even the limitation to the free
Establishment.
that limitation it is admitted recognized by the court. This is a particular situation here, and of course this limitation does have to follow have to have a very good reason, and it is the case law of the European Court of Justice is very, very well developed. But I know the case against Italy, and the European Court of Justice said, well, okay, the purpose followed by the national law. Well,
yes, that's what
we.
I bet we all know the case.
It's not illegal.
Yeah. We have to continue. No, it's not the same thing. Yeah. Right. I think we can continue with that case in the break, but what we have also to do is a retroactive effect, which takes a lot of time. I will not stick anymore with case 2. I mentioned the data retention directive, and I don't think that's partly it was answered. But nevertheless, just a few words. So we know that ECJ ruled the directive and data retention directive is not in line with the treaty function of the European Union. Here are 2 cases. Imagine that you had been faced a year before that ruling with the question that the national law is incompatible with the Constitution. Because the national law, which implemented the directive, at least of the opinion of the plaintiff, violates the right to privacy. At the same time, the Commission had also started the infringement case that the directive is not properly implemented in your country. So this is now, in addition to what we previously discussed. You are faced with the question of the plaintiff, the maintenance of the plaintiff, saying, well, it's not in line with the Constitution, violates the right to privacy because all these phone conversations, durations, who make a call, who was a receiver, they were stored for several years, and it violates the right to privacy. However, it's not the end of the story. You're faced with the question first, whether Constitution is not in line with the directive. It's a hard question. And secondly, there is a Commission starting a procedure against member state, which will not, of course, come to your court, because that is a procedure of the European Court of Justice, saying that the directive is not properly implemented. Now, what I wanted to show you with that case, there won't be equal questions. Commission will say you did not implement it correctly, and here there is a question of the right to privacy. The legal basis will not be the same. So what to do? It's a two. No.
It's so obviously wrong, this directive.
Yeah.
You don't wait at all. Rules say it's unconstitutional.
Yeah. Now we know it's unconstitutional. It's
Everybody knows.
Yeah.
Everybody knew before.
right, but if you
Only the Commission did know. Even the Commission knew. They only instituted this proceedings because of political pressure from one member state, the one I belong to.
Okay, but imagine that case, and you are faced with that question. The first one. What will you do?
I won't wait. I will decide on my case on the basis of my constitution, and I will, or whatever, or even on the European Union Charter, whatever, European Charter of Human Rights. I would not have waited because the action by the Commission is only action by the Commission. It's not in any court at the moment. Even if it's in the European Court, it's so blatantly wrong.
I agree with you. I agree, but
only if the Commission says you did not follow our rules in implementing, it doesn't say the rules. The directive itself is right.
I know, but
only the implementation is missing.
Just a step back. Just a step back. You said it's so obvious it is wrong. If it is so obvious that it is wrong, that is not in line with the Constitution, but not in line with the treaty, right?
Yeah.
You have to, even if you are in the first instance, you have to start preliminary ruling procedure, asking whether it is void or not.
Yes. But I wouldn't do it as an alternative.
No. That is must.
Yeah.
That is must. So
Yeah.
you have to do it.
I would still continue with my case. I would not stay my case. I would ask for a preliminary ruling, maybe, but I would continue with my.
No, it's not maybe. It's not maybe. This is not written in the treaty. This is the Costa case. If there is a doubt on the legality of the directive, you have to, even in the first instance, you have to start preliminary ruling. You don't have to go. You shouldn't go further with your case. Okay, and that case. And that case that Commission started has no relevance. That case the Commission started has no relevance for you as a judge. Okay. Now, we are really left only with one issue more. That is the issue of retroactive effect. What can happen? It can happen, and perhaps let's go directly to this case, Kuhn and Hitz. I hope I pronounced it correctly. It is about that. Namely, there was a poultry meat in question and export refunds. That company, Kuhn, got a refund, export refund for exporting this chicken legs. However, they've got quite a sum of money, more than several millions, okay? And then the authorities decided that there should another tariff should apply, namely these are legs with certain back parts also on the legs. They are not only legs, and it's another tariff. And according to that another tariff, heading as other meat, the export refunds are substantially lower. So that company had to pay back to reimburse the state for 2.5 million euros. And that company also learned that there was a case decided afterwards by the European Court of Justice that basically that part of the chicken leg and a little bit head together, it's still leg. So they were entitled also to this 2.5 million euros, right? So what to do now? We have a decision, administrative decision, final one. We have a final court decision, judicial decision, res judicata, and there is another case, independent for that one, decided later on by the European Court of Justice. Can we reopen this case? Right? And the court basically said that it's possible. However, coming back to the cases, to that case immediately, but let's add a little bit to the list of cases that I'm referring here to. Namely, the court did a huge differentiation between final administrative decisions and res judicata on the other hand. Final administrative decisions can be reopened as a rule, as a general rule, and I will later on in the next slide there are these rules written, while final judicial decisions, res judicata, usually cannot be reopened. It is only in the case Lucchini, the court said, well, you have to reopen that. The case Lucchini is extraordinary case. The case Lucchini refers to the state aid, to the exclusive competence of the EU Commission, and this was a flagrant violation of EU rule, saying basically that certain company is entitled to the state aid, and the Commission was saying all the time, no, it's not entitled, and Lucchini is an exemption. Usually, res judicata will hardly be open. But let's go back to the case, back to the rules when the administrative cases can be reopened. As I said, the issue started in Knez, then cases like I-21 and Arcor offers a new guidance, which is written here. First, the administrative body must, under the national law, have the power to reopen that decision. As I said at the beginning, this reopen is everything that we are learning from the court and for the AG. It's up to the national law. And here, the difference will be a huge one. Secondly, the administrative decision in question must have become final as a result of a judgment of a national court ruling at the final instance, meaning that that individual had to started also a court procedure for annulment of that judgment, of that administrative decision. Otherwise, the second condition is of no meaning. Thirdly, that judgment, national judgment of the court judgment, in the light of a decision given by the court subsequent to it, be based as a misinterpretation of community law, which was adopted without a question being referred, meaning acte clair, in the circumstances, okay, acte clair. So there was a court procedure, and at the end of the day, Supreme Court ruled without posing a question to the European Court of Justice. And thirdly, the persons concerned must have complained to the administrative body immediately after becoming aware that that decision of the Court of Justice. So there is no time limit given by the European Court of Justice. It's again up to the national court saying, well, if there is in a certain time limit, appropriate time limit, going back, this individual has to go back to administrative level, asking for reopen the case to issue another decision. Now, what we can see here is that these are basically guidelines. It's up to the national procedural rules whether this is possible to follow or not. One thing. Another thing, I don't think these four conditions, very important, nota bene, that these four conditions are still in line as it stands here. Because there was a case that I mentioned before, I did mention, it's on the list. The last case, final administrative decision from 2011, 249, Cristo Bianco, where the court said that it is not necessary that the individual seek a legal remedies at the court. So he can stop at the administrative phase, final administrative decision, not going to the court trying to annul, seeking to annul the administrative judgment. The court did not refer, in that Cristo Bianco case, did not refer to case I-21 or ARCO in a sense that I'm referring right now. The court did refer to that case, but not in that sense. The court did not say that second and third condition from case I-21 and Arcor are not applicable anymore. The court simply ruled saying, even without individual trying to, right.
I haven't understood. I don't think I really understood what you mean. Because you first said that the court generally thinks that where there is a res judicata, it can't be reopened. Did I understand correctly?
Yes, but...
If there is a res judicata, that means it cannot be reopened. But then you say that the hypothesis...
I know what you want to say. I wanted to come back to this. Res judicata stays res judicata. Again, like in the Kubler case. Res judicata will not be changed. However, administrative decision will be changed, will not be in line with res judicata, but it doesn't matter. We are not reopening res judicata.
So why is it required that there is a res judicata? I mean, your second requirement means that there must be a res judicata.
Yes. We have to defer different cases. If we have a res judicata case without a previous administrative procedure, for instance, in private law cases, right? There is no administrative decision, no administrative procedure. And then is a res judicata. Usually, general rule, you cannot reopen it. But then another case, you start with the administrative procedure, final administrative judgment, then you go on to the court, final administrative court decision. Now, there is another case from the unrelated case. You don't go back to the court procedure, you go to the administrative procedure. And you try to reopen the case. At the end of the day, there will be another decision, which will not, of course, be in line with that res judicata. So the solutions will be different, but that res judicata...
New administrative procedure, so you get a new administrative court procedure.
And this res judicata stays res judicata. Yeah, there is a last slide, if I may. Just a toolbox. So consistent interpretation, direct effect. That's two relatively well applied tools for every judge. If this is not possible, state liability, of course, according to circumstances of the case, it's also possible and wise to stay the proceeding, and in cases of in cases where there are influences to already decided cases, retroactive cases, reopening is possible, mostly on the administrative decision and not on the judicial decision as res judicata. I'm sorry I was 8 minutes late. I was happy really for questions that you posed, and I was enjoying. Thank you very much. Thank you.